Good afternoon, everyone, and welcome to Fridays with Keenan's Cutting Edge. My name is Jenna Labor, and as always, I will be your host as we explore the dynamic world of Don Keenan's trial philosophy, The Cutting Edge. Those of you joining us live this afternoon have the opportunity to ask questions and interact with our speaker. If you have a question, please enter it into the comment section below so that we can address it. Episodes are released each week following the live broadcast, so be sure to hit that subscribe button and click the alerts icon to make sure you don't miss an episode. Today's guest needs no introduction, as the saying goes, as we have David Hoey with us again to talk about Trial Management College. Hoey is generously giving us his time mid-trial prep, so we appreciate him being here very much. As always, we'll put his contact information in the description below, so you can contact him directly with any questions you have about this college or anything Edge. All right, Hoey, this is a great one to come after the trial college we had last week, or the discussion we had last week with Blake, because they're often confused. So talk to us about Trial Management College and what we can expect when we attend.
Thanks, Jenna. Yes, the trial course is entirely different than the trial management course. And trial management course, I always recommend, is the last course out of all the courses that you should take. And you should take it with a case that you absolutely know is going to go to trial. And then apply what you've learned from trial management into all the rest of the cases you eventually take into trial. Or come take trial management more than once. Every time you have a case that's about ready to roll for trial. Structurally, I'm the only one that teaches the course, and I only offer it once a year, usually every December. But there's been such a strong demand for it, we're going to offer it twice this year. It's going to be in August, and then again in December. And there's been some minor changes and tweaks to it because the format in trying cases around the country has changed a little bit. I tried a case in August, and it was the first case tried in that county courthouse since the pandemic. And we had to wear masks, and there was plexiglass up all over the place. And the jury selection process was one-on-one instead of in a group. And so adjustments had to be made, and trial management decisions had to be changed. So, depending on what's going on and what part of the country you're in, there's going to have to be some trial management decisions made, sometimes on the fly, but usually we know what's going to happen. We can plan ahead for it. I'll talk a little bit more about the structure of the course. But I want to, for those who don't know who I am the Dean of the Students for the Keenan Trial Institute, which is a national trial college. It's the only kind in the country, and probably will be the only kind of this nature in the country. I was appointed by Papa Don back in 2012 into 2013. And that's another story in and of itself, and probably better served for another day. It's a voluntary, non-compensated position. Myself, as well as our administrator, Tony Seaton, which is also a voluntary, non-compensated position. So people often ask, why do you do it then? Because, folks, it's true plaintiff's lawyers, it's not about the money. I know that's one of the purposes of tort law, but there's 2 to 3 other purposes of tort law that apply. Deterrence, community values, and safety. Compensation is only one of those elements. So why do we do it? Because we believe in the EDGE system. We've had success for a number of years using the EDGE system. We like to teach. Tony and I love to teach. We love to help. And we have a high level of respect for Papa Don. And I enjoy the people. I just wish and can't wait for us to get back together again. This is a great way to learn and do a podcast and all this type of thing. But Jenna, you're way over there in Washington. I'm way over here in Boston. It's a great way for us to see each other.
Mhm.
But I do truly love, being together and, having a social event. And I hope it does go back to that again one day. So as I mentioned, I only teach it once a year. I'm going to teach it twice this year. It's 2 full days, although I'd like to extend it to 3 at one time so we can take our time at it. So what is really trial management? Trial management, like all things Edge, is a system. It's a structure and a system of organization. It's how to organize your time and your case to get through the trial process, the trial system. And that starts with the things you need to do before you even pick a jury. And then there's a system to the voir dire process. And then there's a system to the opening statement. And there's a system to the order of proof. There is a system to the law. This course is heavy on black letter law. And you prepare for obviously the issues in your case, but then common issues, conscious of the community. You prepare by doing the law research and preparing a bench memorandum, and you have it ready when you need it. Feasibility happens to be a new common legal issue that needs to be bench memoed. Foreseeability, right? We know that no judge truly understands the concept of foreseeability. Well, we got to brief it and give it to them. There's a whole list. These are some of the things that we go over in the trial management course, is every single one of those topics and what your bench memorandum needs to look like. Every motion you file, every memorandum you file with the court on the plaintiff side has got to have the case billboard. And the case billboard is just a way of which you're going to communicate your case in its most simplest form. And so we spend a lot of time making sure that is correct. I'll give you a quick example. On Christmas Day of 2015, Mary was dropped out of a Hoyer lift by an aide operating the lift. Insufficient number of staff were available to help her, so she operated it alone. Broke both of Mary's legs. Never sent to the hospital. 22 hours later, she dies of internal bleeding. The owners, initially understaffed, under-resourced their nursing home to save money. The public has a right to know. Those responsible for this wrongful death need to be held accountable. That's it. That's a case billboard. Kind of choppy because I just wrote it about 5 minutes ago. But that's the way it's supposed to work. And that message is over and over and over, and it's repeated and repeated and repeated. And in some instances, the judge has seen it so many times, that's how the judge describes the case, him or herself. So we spent a lot of time getting the case billboard done. We spent a lot of time getting the black letter law bench memorandums outlined and what you're going to need. We spent a lot of time on the case selection criteria. You got to go back to the basics, folks. Why'd you take the case? Why should the community care about this verdict? And these are the pieces that get you pre-organized for putting your case together and your order of proof. Now, another big part that I hear from the students that they enjoy about trial management is the routine that we teach. As some of you may know, Papa Don was Marine Corps trained. And if you're Marine Corps trained, he went to officer candidate school. Everything's a routine. from the time you get up in the morning to the time you go to bed, to the meals you eat, to the uniform you wear. Well, trial management is a routine. We get up at the same time, we go to bed at the same time. We do the exact same things every day, Monday through Friday and Saturday, and take Sunday off. And it's important because part of that routine, built into that routine, is the trial team. Who's part of your trial team? We do not recommend that you ever try a case alone, but your trial team is going to be a lead, a second chair, sometimes a third chair, and you're going to have other people involved in part of your trial team. You know, someone to handle the client. And then you take that trial team and you break down its labor. Who's responsible for what? And where are they going to get help if they need it? And also part of that trial team is your ethics lawyer or law school professor who's on call or watching the trial and ready to go when those appellate issues or hard legal issues come up. It's just a phone call away. These are parts, you know, I'm giving you an awful lot in a short period of time, but if you come to the course, each one of these pieces is elaborated on. And we go pretty much in depth as to the trial team and the labor of all the participants of the trial team and the order of proof, visuals in terms of demonstrative evidence. So that's another bench memorandum, is the use and admissibility of demonstrative evidence. What is the law in your state on the use and admissibility of demonstrative evidence? As it differs little by little. Some states you do not have to give the other side your demonstrative evidence. Other states you do have to give the other side your demonstrative evidence. They have time to object or do whatever. And in a case I was just recently involved in, we had to give it to the judge for approval a week ahead of time. And the judge approved it a couple days before the start of trial, as long as you had a witness who was going to testify to its contents. So a couple other things that we introduce in the trial management is the use of the courtroom. Where you stand, where you sit, what you say, what you do, how you say it, how you do it. The use of flip charts and magic markers. And you say, oh, you know, that's nothing. What's the matter with flip charts? No, I won't go into it in that much detail, but if you've ever seen myself or Mr. Keenan at trial, you see that we put everything in front of the jury. And the only way to get testimony from a prior witness in front of the jury is by using the flip chart. So let's go to the flip chart. What did the witness so-and-so say yesterday? Well, here it is, marked for identification, letter A. The witness said ABC, right? Do you agree with that, Mrs. Witness? No, I disagree with that witness. Okay, let's put what you said down on the flip chart. So it's a visuals, right? Visuals. Some visuals need no explanation. But the key to trial management is organization. We also organize by using binders, old school binder system. You know, we have a binder for everything. There's a binder for the opening. Well, what's in there? Two things: the opening and the anticipated objections that they can make to the opening, right? And how we're going to get around it. That's it. Nothing else, right? And you have the first witness. First witness is a police officer. The police officer is going to talk about the crime statistics in the community. What's in the binder? the police officer's profile, the police officer's direct exam, and the bench memo on the use of the crime statistics at trial. And whatever exhibits you're going to use with that witness, they're also in that binder ready to go. You're not fumbling for anything. You're not looking for anything. You're not asking your second chair, hey, do you know where that photograph is? No, everything is organized in one place, labeled, ready to go in its simplest form. Don't hand me a direct examination notebook or binder that's 30 or 40 pages deep. I'm not going to read past the third or fourth page. It's just not going to happen. Sometimes when you're dealing with certain kind of experts, you're going to have articles that they might have published, lectures that they might have given, and bad things in their CV. I get that. Experts are really a different camp. But so what I try to do at trial management is make it friendly, keep the class small, go around the room and find out what your fears are. Because then once I know what your fears are, I can help you remove your fear. And when I help you remove your fear, that gives you confidence. And the other thing I'm looking for is to make sure you're still passionate. You're still passionate about your client. You're still passionate about the law. Because if either one of those is missing, then I'm going to tell you you're not ready. So, there's so much more to it. This is it on a quick surface. Try to tell you this a little bit more without revealing.
What kind of things do we need to have ready beforehand? Like, what do we need to bring if we do this course?
Well, you need to have your case done. Discovery's got to be done. Experts need to be disclosed. A trial date is helpful. Not a trial date that's less than 30 days away, because you're not going to be able to have enough time to implement.
What's the window there? Just as a side question, what do you suggest? Is like 3 months, 6 months?
60 days prior. Well, for the court, we have a rule that our case should be in the can, ready to rock and roll at least 60 days prior to the start of the trial date. Our case is ready. Now, the defense may be doing things within that 60-day window, which causes you to react and do more things. I get that. And the judge may be moving around your trial date or requiring you to submit more filings and black letter law memos or what have you. I get that too. But if everything else is done, that stuff becomes very easy. Very easy. So we have this rule: 60 days out before trial, your case needs to be in the can. For this course, though, 60 days or more, you can still work in a lot of what I teach in trial management into an up and coming trial. At least get organized enough. At least put together what your trial team is and what the labor is going to be. Who's doing opening? Who's doing closing? Who's doing voir dire? Who's doing liability? Who's doing damages? Who's going to argue motions? You can't do it all. Who's going to watch the jury? Who's going to watch the judge? So there are parts there that can get implemented within a 60-day period. Client profile is real important. I wrote a blog about it a few months ago, and the importance of the client profile. You got to dig deep. As plaintiff's trial lawyers, you're also a therapist, right? You're also a financial manager, a doctor, a lawyer. You're all these pieces, obviously not by degree, but because when your client comes to you for advice, your advice is multi-layered, and your client's harmed, and doing certain things could further harm your client. So there's a balance. The decision as to whether the client attends trial, right? That's a major decision. And the client needs to be involved in that. There are clients that don't want to know everything because it affects them emotionally. So you have to balance what I need to tell them versus stuff that's going to really affect them, really going to harm them. Mm-hmm. And here's something that I've learned sort of kind of recently. When there's media attention on your case, and that's another thing we talk about in trial management, is whether the case is media worthy and what the pros and cons are having media follow your case for whatever reason. Today with social media and all these Twitter and Instagram and Facebook and all this other stuff, when your client's matter is in the media, you better be following what's going on in the social media about it. And it's usually nasty. And then you got to determine, well, it's out there. I know my client didn't see it. Should I be the one to tell my client? Or because it's out there, she might find it, he or she might find it on their own. But it's an issue. It's becoming more and more popular now since the pandemic. And it's dangerous. It's really, really a dangerous place. So we talk about that also in trial management. The biggest takeaway that I see is the billboard, the routine, getting your billboard down, the defense strengths, where you're going to give the defense credit, and then how you're going to deal with it. The demonstrative evidence, the routine, the use of flip charts, and it just escaped me for a second. It'll come back to me in a minute. Well, here's something that we could talk about for a second. When you have a case that has 14 or 15 or more depositions, right? And what happens is that in the direct and some cross-examinations, you're referencing other people's depositions, and you were taken in a deposition, and blah, blah, blah. I can tell you right now, the jury doesn't know what a deposition is. And so it would be our job to ask the judge to please tell the jury what a deposition is. Yeah. And even some judges struggle with that. What do you suggest I tell them? And the key is that they need to know that it's testimony under oath. Okay? And that's a quick little trick. Stop using the word deposition and saying testimony under oath. No. When you testified under oath, blah, 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 blah.
I find one of the hardest things to explain to a jury is that testimony is evidence. I have had so many questions from jurors in the deliberation room where they're like, well, we want to know, is there evidence of this, or is there an evidence of that? And I'm like, oh my God, you just sat through 2 weeks of evidence. What's wrong with you? But it's weird. It's a weird concept.
It is. And if that's a problem you're having, that's something you can clean up in closing. Now that that's an ongoing issue with jurors, there's a place to plug that into a closing. Actually everything they see, although it's not termed evidence, everything they see and everything they hear that goes on in the courtroom is part of their juror experience, right? And they take their life experience into the deliberation room.
Yeah, I think that's one thing I would like to get better at is telling them that you can use your life experience in there. Because I've worked in the part where I say testimony is evidence. You're not going to have anything in your hands when you get back there. So here's, not that it necessarily helps, but I also feel like, because the defense inevitably comes back in their closing and says, you can't use emotion. So if you're feeling emotional, that's okay, but you can't use it. All right. So make sure you're not being emotional. And then they take it a step further, and the jurors, because they want to do their duty correctly and eliminate any human nature from their deliberations. And I recently had a gal say, well, I knew somebody with a brain injury, but I didn't want to make it about my situation. So I didn't talk about it. And I was like, oh man, should I have anticipated that and told them? That's hard. It's hard to remember everything you're supposed to tell them to do in there.
Well, here's your litmus test. If you've done enough focus groups, they're going to tell you what they want to know. And then you have to trust them. And that's what you're going to have to provide the real jury, because the 6 or 7 focus group juries told you what the real jury is going to expect, but the whole testimony under oath. And that's the key is, if you say, ladies and gentlemen, the jury, testimony is evidence. You can consider that as part of the evidence in this case. And Mr. So-and-so testified on the stand, blah, 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 blah. What's missing is the oath part. It's under oath. They swore that it's true. Then Bubba's antenna goes up. So it's just, those are little tweaks, and that's the perfect example of a little tweak that I would teach in trial management. And that would be a fear or a disconnect or a problem you're having. And then we'd address it with the class, and we put that together, and then you'd feel confident about it.
Yeah, absolutely.
And there's many facets and pieces about that, and describing foreseeability to a judge, describing foreseeability to a jury. I'm not going to tell you here, but I can tell you how it's done, within the 4 corners of the black letter law.
That's a good point. So we always get a reptile motion or whatever, pretrial motion and that sort of thing. Do you ever teach in any of your courses that we violate the golden rule, or that we try to manipulate the judge or the jury? Is that something anybody's going to learn in any of these colleges?
No, because if anybody has learned anything from this, what is practicing the edge way? Well, it's easy. It's following the black letter law, simplifying it so that it's easy to understand, streamline discovery, and shorten your trial time. Because today's jurors' attention span is about a nanosecond. That's what practicing edge is. That's what it is. It's not manipulating. It's not doing any of that crap. It's really, really simple. Follow the black letter law that applies in your jurisdiction. If statistics are admissible, they have a use and admissibility in your state, then it's okay. If it's not admissible and doesn't have a use in your state, then it's not okay. Then don't go against the grain. Okay? Economic feasibility, when they make changes. The economic feasibility is a way to get around subsequent remedial measures. Black letter law. But you got to have the memo ready to go. So, I can't repeat this enough. And I've mentioned this to many, many judges. That's why when I used to get hit with these anti-reptile, anti-edge type memos, what the what the other side is asking the court to do is to not follow the black letter law. Right? Like, so golden rule in Massachusetts, for example, you can't use golden rule for liability, but you could use golden rule for damages. The other side tries to put a complete blanket on the golden rule on all the elements of the case. And I have to educate the judge and say, Judge, we know the golden rule. We're not going to break the golden rule. But it's admissible under the damages side of the case. And then, the judge pries a little deeper and always says, well, then how are you going to use it? I said, Judge, I can't give you pieces of my closing argument. Right? That's one of the things that are sacred, the lawyer's closing argument. But then you better not break the rules in the closing argument. I've been yelled at. I agree. I've walked the fine line, and I got to tell you right now, not intentionally. You're in there. You're going at a good pace. You're getting emotional. You're passionate about the case, and you might say something you weren't supposed to say. Where you get in trouble is when you do it intentionally. But practice and knowing the law on closing arguments helps. We cover that in trial management as much as we can. So yeah, I'll repeat it over and over and over again. Following the black letter law that applies, simplifying it for a court and a jury, streamline your discovery so it's pointed, and efficient trial. Those are the three parts. It's always been like that. The other side has made it something more that it is not. And I used to take it personal, but I don't anymore, because the truth at the end of the day is the verdict.
Yep. Yeah, that's been a theme through all of the podcast episodes and everything else, is just really know the law. And you're going to have judges who don't want to follow it, who fall for the defense, whatever. But as long as you're following the law, you're in the right. So whatever ruling the judge makes, you can rest assured and feel confident that at least you argued the right side, the correct side.
Yeah, even if the judge is going to shoot you down and tell you it's not applicable, or I disagree with you, counsel, or what have you, make a record and appeal it. Nobody really wants to be in the appeals court, but that's where a lot of law is made, and that's where a lot of law is upheld.
Do you talk to your clients about that beforehand? It's kind of a weird thing to discuss, because then it's like, well, things might go sideways, so be prepared. But
that's a good question. In the past, the early years, we never really talked about the appeal because we never anticipated being there. And if we had lost a trial, very seldom would we appeal. And when we did, we knew that we were in high probability of losing on the appellate level. So there really wasn't much of a discussion with the client other than, we're going to, if you're okay with it, we're going to appeal it. And clients oftentimes would say, oh yeah, okay, because they had already lost at the trial level. This is, but as time has gone by, and we found ourselves in the appellate court more often, we'd have to hire an appellate lawyer, not try to do the appellate ourselves, and then have the client meet with the appellate lawyer. And now we've created an appellate team, and collectively we would try to win the appeal.
I think that's
Yeah.
something I'm going to incorporate more into my practice, just because in a recent case, there were so many good appealable issues because the judge made some really bad rulings that impacted the verdict. And at the end of it all, the client was like, no, no more. No, I'm done. I don't want to do this anymore. And that's on me, right? Because I didn't have that conversation with her because I didn't foresee what happening. But it was just definitely gave me pause to think about when to have that discussion, how to do it, and make sure that they're on board with it.
It's you only get 30 days to do a notice of an appeal, right? And sometimes a client isn't over what happened within that 30 days. I have found that most of my clients get pissed off, and normally later in my career versus earlier in my career, judges are making a lot of errors. And so the success rate on appeal has gone up, and the clients are now getting pissed off when they lose a trial, and they're blaming the court or they're blaming the judge. And I would say 60% of the time the judge was wrong. And then the client, you would think, is happy. No, you got to remember what the purpose, why the client was bringing the case in the first place. And you got to be very cautious when the client's motive is money. But when the client's motive is they want to get the word out, they want a safer car, what happened to them, they don't want to happen to somebody else, and they want to be an advocate as well as the plaintiff. Well, then you got a different motive.
Yeah.
You got a different motive. But the defense always thinks it's just about the money. And it's not just about the money. It's about the purpose of tort law. We live in a safer society, in a safer community because of plaintiff's lawsuits. Even when a plaintiff loses, a defendant may take it serious and change the way they're doing things. I did nursing home cases for 25 years. It took a long time, but yeah, they started changing their ways.
Yeah, it takes a long time, I guess. And that's sometimes I feel very hopeless about that sort of thing. I'm like, are we doing anything? One little case at a time. Oh my gosh. And I had a focus group one time tell me, I said, well, what if I were to tell you that this verdict is also, going to make a change in the defendant's behavior? They said, no, there's been so many lawsuits and it doesn't change. We don't care. I'm like, sometimes I feel that way.
And like I said, I didn't realize the changes that were being done or made until later in my nursing home case career, when the other side would call me up and say, we don't want to go through what we went through with you last time. And they will settle for more money, or they'll say, what do you want out of this? And I say, look, my clients are looking for a staffing change or a policy change or something, some apology, something. So it does make a difference. It does. And whenever somebody has to pay out money, it's a sting. Whether it's an insurance company or whether it's the defendant themselves, there's a sting there. Even if they lost. I used to tell my clients this when I lost a nursing home case, which wasn't that often, but there was a few there. I said, no, you won. It's because the jury didn't give you compensation for the loss of your mother or your father. You put that nursing home through the system. You put them on trial. You made their people testify. You published their policies and procedures. You got media attention on it. Yeah, you won. You just didn't get compensation for it. And they will definitely think twice before they do whatever they did again, because they do not want to get sued again. It's too risky. So yeah. verdicts, positive or negative, are good. And they just needs to be presented in a better way than the way the insurance industry or the defense attorneys present verdicts as a bad thing. They're not. They're not. So I know we're getting off a little bit on
That's all right.
a little bit of a tangent.
We kind of go where the conversation takes us.
Yeah.
So to bring it back, I guess, a little bit to the trial management course, though, because realistically, discussing all of this stuff and strategy and theories and everything really goes into what that course is about. But to differentiate it between trial, what we learned last week with Blake about weaving in edge concepts through testimony and that sort of thing, trial management is a little bit more logistics. You're still not going to be like, hey, this is how you introduce exhibit and this is when you do it, but it's a little bit more about the logistics of keeping a trial organized.
It's the organization aspect of it and the routine aspect of it. And you got to have everything ready so that you have the confidence of, I'm prepared. You know, I am prepared for anything. I am ready for that smoke and mirrors show that they're about to put on. And I'm confident. I've done all my legal bench memorandums. I've done all my topic notebooks. I've got my game plan. I've got my organization chart. My flight is booked. My hotel is booked. I got my flip charts. I went shopping at Staples. I'm ready to go, you know, and it really eliminates all of this last minute running around where you get scattered focus, which is one of the reasons why we lose a trial. You have all these loose ends that you didn't tie up. That's a second reason why we can lose a trial. You know, I can't tell you how important it is to be trial ready. You know,
has anything changed about the course based on virtual trials?
It will. When I teach it in August, I had just finished a virtual week-long, more than a week, in January, arbitration. And the arbitration is a trial too. You got 3 arbitrators versus a jury of 8 or 10, right? And you had to put up exhibits. You still had to cross-examine witnesses, direct exam witnesses, put an expert on. Yeah, there's some pieces to it that we have to change to. I'm still trying to flush it out. I can't say I'm a fan of it. It was because you're sitting here in this chair the whole day, right? Other than the breaks you take. And then you got your other screen over here where you might have an exhibit on it, you know, and then you can't hand the witness anything. You got to address the witness to the screen, right? And then you got 10 people on the screen.
Yeah.
You know, it's something I have to get a little bit more used to. The sad thing is I was suffering from COVID during it.
Oh, no.
But I didn't want the other side to know that.
Yeah. I mean, at least then you can, so like even say you're sick or something, but you're still able to do the trial. You're able to do it in the safety of your own bubble.
I was wiped out. As soon as the day was over, I went right to bed.
Oh, yeah, I bet.
And had to rely on other people to get the night's work done. But it's the same thing. There's bench memorandums that have to be served, exhibits that need to be marked. Each lawyer has their own task, their own set of witnesses. Checks and balances is another thing that we go over in trial management. So, for example, one of the cases I had with Papa Don, one of my jobs was the opening statement. And they got focus grouped it like 6 times until it was perfect. And so I read it, so that I did word for word, did it kind of like in a presidential format, from the podium. And Papa Don had a copy and he followed it along every word. And if I missed one word, he would have been on me. Mm-hmm. So you have to have, that's just one example of checks and balances. There's about 10 different examples of checks and balances that has to go through.
What about for firms that are smaller and don't have a big team? Do you give suggestions in trial management about how to do that?
I do. You got to get a couple other edgers to help you out. And I got to tell you, this case I was getting ready for, we put the word out to a group and said, hey, we're getting ready to try a case and such. Boom, right away. How can I help? I want to help. I can be there. I can clear my schedule. What do you need? It was quick, and we had whomever we needed at any particular time, because they all understand the need for help. You can't do this stuff by yourself. You just can't. There's just too much, and there's too much at risk to do it by yourself. So yeah, there's help out there. You just got to ask.
Yeah, that is one thing, I suppose, with the virtual trials. People can pop in from, Texas or Massachusetts or wherever, who are edge folks, and can watch your voir dire, whereas they might not be able to do so if you're. Do you have very many edge lawyers in Massachusetts? We have not very many here in Washington.
When Edge first came out, we did a number of seminars up here.
Okay.
And the room was packed all the time, 90 to 100, right? And then there was a major need for it up here. And then the law changed in 2000, I want to say 2012, but it really didn't get going. The attorney conducted voir dire. You can give the jury a number now. Changed. And so Papa Don came up to Massachusetts to teach them how to do attorney conducted voir dire. And again, the room was stacked, packed, He got a standing ovation from the trial lawyers. But then it kind of stalled out. I think there was a lot of fear that, you can't do that up here in Massachusetts. But then I was living proof that you can't. So, I don't know. There's enough for help. Mm-hmm. If I needed more people to help. Mm-hmm. But there isn't a wave like there is in Texas.
Yeah. Yeah, some of those southern states have a very close knit, group of because I randomly will hear from people, I listened to the podcast, or I'm like, wow, I didn't know, here in Washington, I didn't know that you subscribe to the same trial philosophy that I do, I got to keep notes of this. I mean, of course I know Amy Miller, she's fantastic and she's out here, but it's like, can't have Amy come in every single time that we need something. So it's for everybody who's listening, find others, because it really is. I'm a person who likes to do things on my own. I like to do it by myself. I want to do it all myself because I think I'm the best person for the job, but it's not necessarily the case. And so to the extent you can spread out some of that work, get help, even beyond your own firm, I definitely do it. It's a humbling experience when you think you can do it and then you fall on your face.
Well, look, getting enough sleep is part of the trial management system. Those all-nighters, they're not good for you. and they're not good for your client.
Yeah.
So get used to it. Find somebody who's willing to help.
Yeah.
If you got to call Amy every day, go right ahead.
Amy, did you hear that? I'm calling you. I know, it's funny. We get into our own little world and just kind of forget, but I'm going to get better at it. I'm going to work on it, try to reach out to more people. So, Hoey, bottom line, kind of what will we come out of this course with kind of in our hands, ready to apply?
Confidence, organization are the two biggest parts of it. And you're going to learn new things that work, which keeps, trying cases fun. If you're willing to do it. If you're willing to do it. So, there's the trial management course is very dear to me, and I teach through experience. And I was fortunate enough to have a couple cases with Papa Don. So I was able to participate and see his trial management system firsthand. And, we've only spent an hour together today. So when I teach it for 2 days, it's not 9 to 5. You're there by 9, and we're there until, the next morning if we have to be. So, yeah, confidence, organization. I'm ready. I'm ready. Because by the time you see me in trial management, everything else is supposed to already be done. Mm-hmm. Now it's just like, okay, here we go. Let's fix your billboard. Let's get your trial plan going. Let's map it out. Let's get your checks and balances in order. Let's give you the confidence you need.
Yeah. I mean, so many things happen in trial. To have the framework set up, you've done the hard work of getting through the evidence, doing the discovery, what you're trying to present, have a framework of how to present it. It does a little bit to mitigate some of the craziness that can't be avoided.
Well, it can be anticipated.
Yeah.
And then you prepare for, what's the old saying? Prepare for the worst, but hope for the best.
Yeah. Mm-hmm. Yes. Yeah.
Prepare for the worst. I'm living proof it works. Otherwise, I wouldn't be teaching it.
That's true. I mean, you come from it's a special experience you had that you're able to speak from that others, can have as RAs, but when we bring Papa Don as an RA, we don't always get to trial. So oftentimes we get what we want early on. One final question. You mentioned you can take this course kind of up to about 60 days before trial and still be able to implement it. I mean, you don't want to take it too early. Is there kind of a window there, especially given that it's only offered a couple times a year, maybe?
I don't know if there's a too early. As long as the stuff on the case is done. I haven't experienced it where it was too early. I know there's plenty that didn't even have a trial date that took the course, and they just kept the outline ready to go for when they had to try the case. So no, I wouldn't say. I'd say any time, as long as the other stuff is done. One of the other thing that you're going to learn is we often focus too much on the positives of the case, and we don't focus enough on the negatives of the case. So one of the things that we do with trial management is we focus on the negatives of the case. And you may come out of the course saying, I can't try this case.
Yeah, that's good. That is really good. Saves a lot of time, a lot of money, a lot of heartache.
Finding out in the middle of trial that you shouldn't have taken it this far.
Yeah. It's brutal. That's brutal. Doesn't mean that you shouldn't try difficult cases, but it's about being making good decisions, making brave decisions when they're necessary to be made, but not setting yourself up for failure, right?
Well, you make good decisions by having the information to make the decision. And it's one of the things that we talk about in the course, how are you going to make these decisions based upon what you got there? You got more holes than Swiss cheese. Let's figure out how we're going to plug the holes.
Can we knit them all together? Can we close them up? Or is it just...
Or you're going to be left with a hole.
Yeah. Oh, all right. Well, thank you so much, Hoey, for being here. And thank you to all of you who joined us for this week's episode of Fridays with Keenan's Cutting Edge. If you liked the episode today, please click that thumbs up to feed the YouTube algorithm and let the powers that be know that you find this content interesting and useful. And don't forget to subscribe and sign up for alerts so you don't miss an episode. Next week, we take a break from this KTI faculty speaker series, and Young G and I are going to speak to you about turning turds into treasures. This was a topic requested on a listserv, so I hope you attend and enjoy it. Sometimes you take a case thinking it's great, and you find out it's not so great during discovery. How do you make it work for you? Other times you take a case that isn't so great, either out of a favor to a friend, which I don't recommend doing, but maybe there's other reasons. And there are certain ways that you can use kind of edge magic and things like that to, at least not completely lose all of the costs you put into a case. Not every turd will turn into a retirement plan for you, but we're going to talk a little bit about how we've been successful in some really difficult cases. So have a wonderful weekend, you guys, and I look forward to seeing you next time.